Hello everyone, my name is Siti Maisara binti Ahmad Tamiz, and today we are going to discuss on the mitigating and aggravating factors in criminal sentencing. So first and foremost, let me introduce you to the types of sentences first. So the most common ones that we know are imprisonment, fine, whipping, and death penalty. But other than that, the court may also give orders such as good behavior bond and community service. Sentences varies depending on the facts of each case. Here are the flow of sentencing. Before sentencing is passed, the accused must first plead guilty or was found guilty and subsequently be convicted. After that, both defense and prosecution plays an important role, wherein the defense will plead in mitigation while the prosecution will raise aggravating factor. Upon taking consideration of these two as well as the seriousness of the offense, then only the court will pass sentence to the offender. So a plea of mitigation is when the accused asks court for leniency in sentence. During the plea, mitigating factor will be raised, which means that any information or evidence is presented to the court regarding the defendant or the circumstances of the crime that might result in reduced charge or lesser sentence. From what I observed at Kuala Lumpur court complex during my practicum, this plea may be made by the defense counsel on behalf of the offender or the offender himself without being represented. So among the example of mitigating factors includes circumstances in which the offense is committed, age of the offender, criminal records, personal background, and plea of guilty. So the first factor is the circumstances in which the offense is committed. This is a universally accepted principle that the court in delivering sentence would consider the nature and circumstances, such as the type and nature of offense, as well as the rampancy of the offense. This can be seen in the case of Siah Aq, where the court did not impose a death penalty, but instead imposed a lesser sentence due to the reason that the victim of a kidnap was not ill-treated. So age is also a strong mitigating factor wherein children are protected under the Child Act 2001. For example, we can see under section 96 subsection 2 of the Act where it is mentioned that a child aged 14 and above shall not be imprisoned if they can be dealt with any other way. Other than that, we also know that children cannot share the same prison or lockup with adult offenders, and they have their own special court. However, old age cannot be a mitigating factor. For example, in the case of Yahya Salaman, it is said that if old age is accepted as an ingredient to lesser the sentence, then the court will give wrong description to the public that old age are given special treatment if they were found guilty. Elderly as criminal records is also important in mitigation, as first offender is a consideration for leniency, and its provision is recognized in section 173A as well as section 294 of the CPC, that the court may proceed to buy over an offender because of his antecedents or that he is a first offender. Next, we shall look into the personal background of the offender. In some criminal cases like stealing, the reason that the person convict crime is due to financial hardship that they face, which makes them have no choice but to steal. This often we see in news, such as where a mother have to steal formula milk for their babies, as well as where fathers steal bread at a supermarket because his children are hungry. So this can be a mitigating factor to lighten the sentence imposed based on the empathy of the judge or magistrate. However, this cannot be a reason that a person is allowed to commit offense behind just to hide behind this factor. Lastly is the plea of guilty, where it is an accepted rule of practice that the accused should be given credit or discount for pleading guilty, not on the maximum sentence. This means that when the accused is charged, they right away plead guilty instead of opting for going into trial. As we can see in the case of Zaidun Sharif, a plea of guilty is a mitigating factor, as it not only saves the country a great expense of a lengthy trial, but also saves time and inconvenience of many, such as the witness, where the court don't have to call for witness, the public prosecution, they don't have to go through like bundle of documents. Yeah. Now we have come to the aggravating factors in criminal sentencing, where aggravating factor means any fact or circumstances that increase the severity or culpability of a criminal act. So this is raised by the prosecution, where they present aggravating factor in order to seek heavier or more severe punishment to the accused. And among the aggravating factors are prevalence or recency of offense, mode of committing offense, previous conviction, position or status of the offender, as well as the public interest. So first is the prevalence or rampancy of the offense, where the court will give heavy punishment so that it will be a lesson to the public not to commit the same offense, such as drugs, stealing motorbike, kidnapping, firearms, robbery. This is because these cases are happening a lot. So the DPP will ask the judge to give serious sentence in order to stop the offense from being committed again in the future. For example, in the case of PP against Lee Tak Kyong, where the accused was first sentenced with 2 years imprisonment for gang robbery, as well as to pay 50 ringgit compensation. But then on appeal, the punishment becomes heavier, which is the 5 years imprisonment and 6 stroke, as well as 50 ringgit compensation. Next is the mode of committing offense, where the important question is whether in committing the offense the accused did some brutality or not, whether there is a use of force or violence. If yes, then the heavy sentence will be imposed. This is in contrast as to what we discussed earlier in mitigating factor, where just because the guy did not ill-treated the victim, then he gets lesser punishment. But in this, if the way that he conduct his offense is very, very bad, then heavier sentence will be imposed. For example, in the case of PP against Muhammad Safian bin Abdullah, the accused had wounded the victim and took a rope and strangled the victim. The court then imposed the maximum sentence. Again, in contrast to what we have discussed earlier in mitigating factor, previous conviction can also be the aggravating factor, where if the accused has previous criminal record, the sentence will be much heavier. For example, in the case of PP against Ja'far bin Daud, the accused was sentenced with 8-month imprisonment for possession of 0.21 gram of heroin. The DPP then appealed because the accused had 5 previous convictions and 2 of it was for drug offense. Thus, the court enhanced the sentence to 18 months. Other than that, position or status of the offender also plays an important role as an aggravating factor. If the offender is someone that is well known, or especially if they are a public figure, let's say if they are a politician or a celebrity, they might get imposed with heavier sentence. For example, in the case of Datuk Harun Idris against PP, the first accused was a chief minister of Selangor, and he was charged for forgery and helping with CBT. The DPP then used his position against him. The federal court decided to enhance the sentence as the accused holds a high post, so he should have been given a good example to the public. He should be the role model instead of he himself being the offender. Lastly, public interest is also one of the most important factors that the court must consider in delivering sentence. Similar to what we have discussed just now, that position or status of an offender is to be considered because that person was supposed to give good example for to the public. The court cannot simply just pass sentence that will give wrong message to the public. For example, in the case of Yi Tamsun, just because the offender is an elderly doesn't mean that he can simply get escape or have lighter sentence due to his age, which is 78 years old. Especially in this case, the alleged offense is very inhumane and intolerable, so he must get what he deserved.